Your Honor.
Let me get him for you. He's in his office.
Swearing at me?
Mhm.
Peanut style swearing?
Stand still.
Ew.
You.
Well, be more specific. I don't know.
All right, who's up first?
Me.
Who's on first? Is that correct?
That's right. What?
Who's on first with you?
Oh, what's up first? Okay, do you have, I think you have a queue of whatever order you'd like to take your queue, please. It's fine with me. I'm slightly disorganized.
All right, let's go with Mr. Bates.
Mr. Bates, come on down.
This is cause number CR 25-118, State of Texas versus Christopher Robin Bates. Mr. Bates, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. All right, Mr. Bates, I got a few questions for you. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with him and the work that he's done as your attorney?
Yes, sir, absolutely.
Do you have any questions about anything that you've read and signed in your case?
No, sir.
Mr. Schmidt, do you believe Mr. Bates to be competent to enter into this agreement today?
I do.
Have you explained to him his rights as they pertain to this case, including the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Bates, you are charged by indictment with a second-degree felony offense of burglary of a habitation that does carry a range of punishment if you were to be convicted and sentenced to not less than 2 years in prison, up to a maximum 20 years in prison. You could also receive a fine up to a maximum $10,000. I see the plea agreement in your case, and the recommendation is that you would plead guilty to that offense in exchange for the state's recommendation that the court not convict you today, for the court to place you on 3 years community supervision, assessing a $1,000 fine, $290 in court cost, $520 in reimbursement fees. And as a part of your community supervision conditions, you would be placed on the mental health. Actually, you would not be placed on mental health caseload. You would receive a mental health evaluation as a condition of your community supervision. Mr. Bates, is that your understanding of the plea agreement?
Yes, sir.
Any questions about any of that before we go forward?
No, sir.
Okay. Understanding those things, Mr. Bates, how do you plead to burglary of a habitation?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir, I'm guilty.
And has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
The court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the evidence?
No, sir.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, Mr. Hartwell?
Your Honor, only that the victims in the case are supportive.
Thank you, sir. Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. The court defers a finding of guilt on the second-degree felony offense of burglary of a habitation, places the defendant on 3 years community supervision, orders him to pay a $1,000 fine, $290 in court costs, $520 in reimbursement fees, and the court orders Mr. Bates to receive a mental health evaluation as a condition of his community supervision. Mr. Bates, you're hereby remanded to the custody of the probation department so that they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted with Sergeant Martinez. After that, you'll meet with the probation officers.
Okay. I thought you were just being rude. Yes, sir.
Call the 8x8.
Yes, sir.
All right, next up will be Mr. Roy Durst Jr.
Hold down, Roy.
All right, Mr. Durst, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Mr. Durst, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
I just had one I put the PS in my seizure disorder. Yes. Okay, so that's not a mental disorder. Okay, so the answer would be no. Okay, then no, sir.
No? Okay. In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about the paperwork or anything that you've read and signed today?
No, sir, he explained it all.
Okay, good. Mr. Schmidt, do you believe Mr. Durst to be competent to enter into a plea agreement?
I do.
And have you explained to him his rights as they pertain to the case?
Yes, sir.
And do you feel like he is entering into this agreement intentionally, knowingly, and voluntarily?
I do.
All right, Mr. Durst, you were charged by indictment with a third-degree felony offense of injury to a, Mr. Schmidt, help me out here just because it includes child, elderly, disabled.
It would be a disabled individual, Judge.
Okay, thank you. You were charged with injury to a disabled individual, a third-degree felony. However, the plea agreement today appears to be to a lesser included offense of a Class A misdemeanor, assault causes bodily injury of a family member. A Class A misdemeanor has a range of punishment up to a maximum 365 days in the county jail and a possible fine not to exceed $4,000. I see that the plea agreement you've reached with the state is, upon you pleading guilty, the state's recommending that the court consider the evidence and then convict you of the lesser included offense of assault causes bodily injury of a family member, with punishment being assessed at 106 days confinement in the county jail, for which you would receive credit for time served. In addition, you would be ordered to pay a $750 fine, $270 in court costs, and $520 in reimbursement fees. Is that your understanding of the plea agreement, Mr. Durst?
Yes, sir.
Any questions about any of that?
As long as I can make arrangements for payment arrangements, then no, sir. Other than that,
And to answer your question, yes, you will be able to make payment arrangements for your fines, court costs, and fees.
thank you, sir.
Okay. All right. Understanding all of those things, Mr. Durst, I have to ask you at this time, how do you plead to assault causes bodily injury of a family member, a Class A misdemeanor?
Guilty, sir.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And that means no one's threatened you, forced you, or pressured you to plead guilty, correct?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that I believe the court should have a victim impact statement on this case. If not, I'll make sure that we get that to you quickly here. And as far as victim support of the plea, Your Honor, the offer was made based off of the victim impact statement after all of the agreement. The victim hasn't expressed really one way or the other, only some concern for any ongoing violence, but hasn't expressed really an opinion as to the plea agreement.
All right, thank you, Mr. Crowell. And I do have the victim impact statement and the tracking. Anything further from the defense?
No, sir.
All right, the court will consider the evidence and the victim impact statement. All right, the court having considered the evidence finds that there is enough evidence to convict the defendant of the offense. The court will follow the plea agreement. The court convicts Roy Glenn Durst Jr. of assault causes bodily injury of a family member. The court sets the sentence at 106 days confinement in the county jail. Court awards Mr. Durst 106 days credit for time already served. The court orders him to pay a $750 fine, $270 in court cost, and $520 in reimbursement fees. So Mr. Durst, once you are released, you'll need to report to the Van Zandt County Courthouse, to the district clerk's office on the 3rd floor, and discuss with them setting up a payment arrangement for your fines, court costs, and fees. Do you understand?
Yes, sir. Thank you.
You're welcome. All right, Mr. Durst, you're hereby remanded to the custody of the sheriff. I'll have you step over to be fingerprinted. And Mr. Hartwell, I have signed the victim impact statement tracking form.
Oh, just sweet. That's all right. They done by computer.
This one, I'll put into it again.
While I'm signing this one, Mr. Schmidt, next up would be Mr. Bridges.
Mr. Bridges, come on down.
You give me just a moment so I can sign Mr. Durst's plea papers.
There. Bill.
All right, Mr. Bridges, sir, if you'll raise your right hand. This is cause number CR 24-299, State of Texas versus Roger Neal Bridges. Mr. Bridges, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thank you, sir. You can lower your hand. All right, Mr. Bridges, your name is Roger Neal Bridges, is that correct?
Yes, sir.
And Mr. Bridges, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with him and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about the paperwork, your case, or anything else before we go forward?
No, Your Honor.
All right, Mr. Schmidt, do you believe Mr. Bridges to be competent to enter into a plea agreement? Does he understand the advantages and disadvantages of a deferred adjudication plea? And have you explained to him all of his rights regarding his case?
Yes.
All right, Mr. Bridges, you are charged originally by indictment with assault of a family or household member with previous conviction, a 3rd-degree felony. However, it appears that the agreement you've reached with the state would be for the state agreeing to abandon enhancement paragraph 2 on the indictment, which would result in the charge being assault of a family or household member with previous conviction, a 2nd-degree felony. And a 2nd-degree felony carries a range of punishment of not less than 2 years and not more than 20 years confinement in prison, and a possible fine not to exceed $10,000 should you be convicted and sentenced. I see the plea agreement in the case is you would plead guilty to the primary offense. The state agrees to abandon one of the enhancement paragraphs, being enhancement paragraph 2. You would be pleading true to enhancement paragraph 1. And the court would defer a finding of guilt, would not convict you, but would place you on community supervision for a period of 4 years. Court would also be assessing a $1,000 fine, $290 in court costs, and $535 in reimbursement fees. Is that your understanding of the plea agreement?
Yes, Your Honor.
All right, then understanding those things, Mr. Bridges, how do you plead to assault of a family or household member by previous conviction?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, Mr. Bridges, with regards to enhancement paragraph 1, is the allegations in that paragraph true or not true?
Sure.
And has anyone threatened, forced, or pressured you to plead true to the enhancement paragraph? All right. Then the court will take Mr. Bridges' plea of guilt and plea of true. At this time, court also takes judicial notice of his judicial confession. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance with victim notification. Victim impact statement was sent out a number of months ago and was not returned.
Thank you, Mr. Arwell. Mr. Schmidt, anything further?
No, sir.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. At this time, the court defers a finding of guilt on assault of a family or household member by previous conviction. Court finds that the enhancement paragraph has been the court finds that the enhancement paragraph has been pled true. Remind me, Mr. Schmidt, Mr. Hartwell, can the court make a finding of true on this if it's a deferred? I know if it's an aggravated assault or some kind of aggravated, it can't make a finding of a deadly weapon, but can you make a finding of true?
My recollection is that you can make a finding of true on enhancement paragraphs alone. I believe it was pled in the indictment. I understand deadly weapon would be aggravated, which would negate, defer to the court's ability to grant probation. So I think in this circumstance, it is appropriate to find it true.
And that's my understanding as well, Your Honor.
Thank you, both of you. All right, the court then finds that Mr. Bridges, having pled true to paragraph 1, enhancement paragraph 1 in the indictment, court will find that enhancement paragraph to be true, finds that the punishment offense has been raised to that of a second-degree felony. Court hereby defers a finding of guilt on that offense and places Mr. Bridges on 4 years community supervision. And court finds that the state has abandoned enhancement paragraph 2. Further, the court assesses a $1,000 fine, $290 in court cost, $535 in reimbursement fees. Mr. Bridges, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. After that, you'll talk with the probation officers. Next up will be Mr. Pugh.
Which sounds like yours was. My last name is Schmidt.
All right, Mr. Pugh, this is clause numbers CR 25-147 and 2025-135. And also 2025-3, Mr. Schmidt, the plea papers say 25-3.
Oh, I can't recall. We're pleading to the possession of the controlled substance case. All the rest should either be dismissed or 1245. It's all in one packet.
Okay, so it looks like there might be a case. It still says County Court of Law in the heading, but there's 2025-3 and also 2025-135. My docket doesn't reflect the 2025-3, but it is included in the packet. Is that y'all's agreement?
My understanding
Yes,
is
sir.
that all of his business will be taken care of by his plea. I knew he had at least one case filed in the county court of law. I filed a motion to transfer up all the ones that I knew were open and pending, so I expect that's all.
Yeah, 25-3 is a violation of a bond or protective order.
Right, and I don't know if. What,
Then there's a 25,
25, 35,
135.
135?
Yeah, that's an assault.
Violence, I think, is that correct? Okay.
Yeah.
We
That's what-
expect,
Go ahead.
do you show that the assault family violence was transferred to your court, Judge?
Yes, it is on the docket. So right now I have two cases on the docket, PCS and assault. I don't have the violation of bond protective order, but it's included in the plea packet. So
That may be on file. Okay, yes, sir.
no, it's filed because it has a 2025-3 number. So if that's y'all's agreement, I'll go ahead and sign it today, but you might want to notify Judge Winters.
Yes, sir. Thank you.
All right, Mr. Pugh, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Your name is Dylan James Pugh, is that correct?
Yes, sir.
Mr. Pugh, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with his work as your attorney?
Yes, sir.
Do you have any questions about any of the paperwork or your case or anything else before we proceed?
No, sir.
All right, Mr. Schmidt, do you believe Mr. Pugh to be competent? And if so, that he is entering into this agreement intentionally, knowingly, and voluntarily, and that he understands the advantages and disadvantages of a deferred adjudication plea?
I do.
All right, Mr. Pugh, in cause number CR 25-147, you are charged by indictment with a second-degree felony offense of possession of a controlled substance of penalty group 1 between 4 grams and 200 grams. That does carry a potential range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. I see the plea agreement in your case. Upon you pleading guilty, the DA's office is recommending that the court consider the evidence, not convict you, place you on deferred adjudication for a period of 4 years, along with a $1,500 fine, $290 in court cost, $180 restitution, and $520 in reimbursement fees. As part of the agreement, the DA's office is agreeing to dismiss your 2025-3 violation of a bond or protective order, and also 2025-135, your filed assault causes bodily injury of a family member. Mr. Pugh, is that your understanding of the plea agreement?
Yes, sir.
All right, understanding all of those things, Mr. Pugh, how do you plead to possession of a controlled substance in penalty group 1?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, the court has considered the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement today. The court defers a finding of guilt, places Mr. Pugh on 4 years community supervision for the felony offense of possession of a controlled substance in penalty group 1, greater than 4 grams, less than 200 grams. The court assesses a $1,500 fine, $290 in court cost, $520 in reimbursement fees, and $180 in restitution. Court dismisses today under section 1245. Cause numbers 2025-3 and 2025-135. Mr. Pugh, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. After that, you'll meet with the probation officers.
They did, didn't they? Oh, you also.
All right, next up is Mr. Brown.
Oh,
All right, this is cause numbers CR 25-66 and 67, State of Texas versus Corwin Lee Brown. Mr. Brown, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, sir.
Thank you, sir. You can lower your hand. Your name is Corwin Lee Brown, is that correct?
Yes, sir.
And Mr. Brown, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with him as your attorney and the work that he's done?
Yes, sir.
Any questions about your paperwork, your case, or anything that you've read and signed?
No, sir.
Mr. Schmidt, do you believe Mr. Brown to be competent today? And if so, do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Brown, I see in cause number CR 25-67, you are charged by indictment with the offense of engaging in organized criminal activity. However, I see that let me take that back. You are charged with the state jail felony offense of burglary of a building in CR 25-66, and in CR 25-67, you are charged with engaging in organized criminal activity. It appears that the agreement you have today with the state is that you would be pleading guilty to the burglary of a building charge, a state jail felony, and you would be asking the court to approve a sentence of 9 months confinement in the state jail division of TDC, along with a $2,000 fine. As part of the plea agreement, the state would be asking the court to dismiss CR 25-67, the engaging in organized criminal activity. Is that your understanding of the plea agreement?
Yes, sir.
And as part of the plea agreement, you would also be responsible for court costs of $290 and reimbursement fees of $20. You understand that as well?
Yes, sir.
And Mr. Schmidt, what kind of credit time would Mr. Brown be entitled to?
198 days, Judge.
All right, the court finds that the sentence is a legal sentence and fits within the range of punishment of not less than 6 months confinement in prison up to a maximum 2 years in prison. All right, Mr. Brown, how do you plead to burglary of a building?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt today. Mr. Schmidt, any objection to the evidence?
No, Judge.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance as far as victim contact goes. As for restitution, the property that was taken was recovered. Any damages to the building, however, there was no restitution request submitted to the state.
Thank you, Mr. Harwell. Mr. Schmidt, anything further from the defense?
No, sir.
All right, the court will review the evidence. All right, the court, having reviewed the evidence, finds sufficient evidence to convict the defendant of the offense. The court will follow the plea agreement. The court convicts Corwin Lee Brown of burglary of a building, a state jail felony, assesses punishment at 9 months confinement in the Texas Department of Criminal Justice, orders him to pay a $2,000 fine, $290 court cost, and reimbursement fees of $20. As part of the agreement, the court is also dismissing cause number CR 25-67, engaging in organized criminal activity. The court awards Mr. Brown 198 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Brown, once you are released from custody, if you've not already paid off your fines and court costs and fees, then you are to report to the Van Zandt County Courthouse and meet with the district clerk's office and discuss setting up a payment plan so that you can discharge those. Going to prison and getting out of prison or being released out there at the sheriff's office, whether you go to TDCJ or not, does not relieve you of your obligation and commitment to pay fines, fees, and costs. Okay, so your failure to pay those things and set up a payment plan to pay those things could result in you receiving a warrant for your arrest. Do you understand?
Yes, sir.
Okay. All right, Mr. Brown, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted.
And Your Honor, I apologize. We just got kicked off the last about 30 seconds over here, so we may have missed something.
I just told Mr. Brown I was admonishing him about reporting to the courthouse to pay off his fines, court costs, and fees once he is released from custody.
Thank you, sir.
Too bad. Yeah.
Bobby Richards.
Oh, yeah. It's in the.
All right, court calls cause numbers CR 24-109, CR 21-34, State of Texas versus Bobby Joe Richards. Mr. Richards, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can lower your. All right, Mr. Richards, you are Bobby Joe Richards, correct?
Sir.
And Mr. Richards, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with him and the work that he's done?
Yes, sir.
Any questions about your paperwork, your case, or anything else?
No, sir.
Mr. Schmidt, do you believe Mr. Richards to be competent to enter into this plea agreement today? Actually, today's a motion to revoke. Is that correct? Or motion to adjudicate?
Judge, we are on the trial docket for a new offense. We are proceeding on a motion to adjudicate or a motion to, and that.
All right, let me ask you some different questions then, Mr. Richards. In cause number CR 21-34, you appeared before the court on October 26, 2021. And you pled guilty to the state jail felony offense of abandoning or endangering a child. After the court heard the evidence, the court followed the plea agreement that you had reached with the state. The court deferred a finding of guilt, placed you on community supervision for 3 years, and the court assessed a $2,000 fine. In the pendency of your community supervision, the state filed a motion to adjudicate and revoke. And in that motion, they alleged 3 separate accusations of violations. Have you had enough time to read over those with your attorney, Mr. Schmidt?
Yes.
You have? Okay. Mr. Schmidt, does your client waive the formal reading of the state's motion to adjudicate?
We do waive to it.
Does he intend to plead true to all three counts?
Yes, sir.
All right, so Mr. Richards, I see today that your plea agreement to resolve cause number CR 21-34 is upon your plea of true. The state's recommending that your guilt be adjudicated, that you be convicted of that offense, that your community supervision be revoked, that your punishment be assessed at 365 days confinement in the county jail, for which you would receive 365 days of credit. You would be ordered to pay the balance of your financial obligations, which at this time is a $2,000 fine and reimbursement fees of $695. In addition, the state would be asking the court to dismiss CR 24109. Mr. Richards, is that your understanding of the plea?
Yes, sir.
All right, understanding those things, at this time, I would ask you, Mr. Richards, how do you plead to counts 1, 2, and 3 in the state's motion? Are those counts true or not true?
True.
Are you pleading true to those counts because what is alleged is in fact true?
Yes, sir.
And Mr. Richards, has anyone threatened, forced, or pressured you to plead true to any of these counts?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true?
No, sir.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Judge, I do have one question, and I'm not certain if the court can answer that, if I have to go to the clerk, but I'm looking at Mr. Richards' costs. And there is a line item for Linebarger outside collections for $658. Do you know why that would be assessed under his court cost? Or do I need to address that with this one of the district clerks?
Yeah, I don't have that in my plea packet, so I can't reference that, but it's a question for the clerks. I'm not sure how they assess that as a court cost or not, but I've seen that time before, and I know that it's been waived also when there's been no collection, but it is a question for the clerks. I'm not sure if it's a true cost of court.
I understand. It's the first time I've seen it, so I was concerned that he's been in custody. Obviously, he would have had fees that were associated with the probation plea prior. Can't pay them from here, so I didn't know if it was sent to collections. And then they've assessed an additional fee, but
I'm not certain, but I'm sure that Mr. Richards, upon being released, could report, or you could assist him in reporting to the clerk's office to try to get that worked out. If the clerks indicate to me that it's not a true cost of court, then the court can always issue a separate order discharging that obligation.
yeah, thank you.
Anything further?
No, sir.
All right, then the court, having considered the testimony and the evidence, the court finds that Mr. Richards has violated the terms and conditions of his community supervision. The court finds all counts in the state's motion to be true. Therefore, the court will follow the plea agreement today. The court hereby adjudicates the guilt of Bobby Joe Richards, convicts him of abandoning or endangering a child with criminal negligence. The court revokes his community supervision, assesses punishment under section 1244A at 365 days in the county jail. The court awards Mr. Richards 365 days credit, orders him to pay the balance of his financial obligations, and the court dismisses cause number CR 24-109 under section 1245. All right, so Mr. Richards, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you do get released, then if you can't make it over here before 5 and the courthouse closes, then make contact with the clerks and inquire about that. And the clerks do a great job of letting me know whether or not we need to reform a judgment or give you credit on a court cost. Okay, so meet with them and let them know what your issue is and that you have that question. And Mr. Schmidt, if you want to assist him in doing so by emailing or calling over to the clerks, just let me know. If I need to sign a separate order, I will.
Yes, sir. Thank you. Collection, because you were like that. That should go away. So that's what you should have. Good.
Mr. Hogg.
Come on down, Matthew Hogue.
This is cause number CR 25-43, State versus Matthew Tom Hogg. Mr. Hogg, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can lower your hand. Your name is Matthew Tom Hogg, is that correct?
Yes, sir.
And Mr. Hogg, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yeah.
Yes, sir.
And are you under treatment or on medication for that at this time?
Yes, sir.
Do you feel like you have a rational understanding of what's going on in court today? You're not confused or anything of that nature, is that correct?
I understand everything completely, sir.
All right, excellent. And throughout this case, you've had Mr. Schmidt as your attorney. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you have any questions, Mr. Hogg, about any of the paperwork you signed or your case or anything else?
No, sir.
Very well. Mr. Schmidt, do you believe Mr. Hogg to be competent today to enter into this agreement?
Judge, I will say that I have a long history with Mr. Hogg. Mr. Hogg has had some ups and downs with his mental health. He is currently medicated, and I've had no issues with having an ability to communicate with him, and his competence seems intact as of today.
Good. And you've explained to him his rights regarding the case, including the advantages and disadvantages of a deferred adjudication?
Yes, sir.
Okay. And I will comment, Mr. Hogg, I remember us having other hearings, and you didn't seem as healthy during those hearings as you do seem today. So I'm glad to see that the medication's doing you a good job.
Thank you, sir.
You're welcome. All right. So Mr. Hogg, you are charged by indictment with a third-degree felony offense of assault of a peace officer. And that does carry a range of punishment. If you were to be convicted and sentenced at a later date, it would be not less than 2 years in prison and not more than 10 years in prison. And you could have a fine up to $10,000. I see today, though, that there's an agreement on your case, and that agreement is upon you pleading guilty to the offense. The DA's office is recommending that to the court that the court proceed on a lesser included offense of attempted assault of a peace officer, and that your period of community supervision would be 3 years. You would be on the mental health caseload, so we can make sure you stay on your mental health medications, and that they would dismiss 2 other cases that they have in their office right now that they haven't filed. Also, you would be responsible, Mr. Hogg, for paying a fine of $750 and court costs of $290 and reimbursement fees of $520. Do you understand all of those things?
Yes, Your Honor.
Okay. All right, then, Mr. Hogg, how do you plead to attempted assault of a peace officer?
Guilty, Your Honor.
And Mr. Hogg, has anybody threatened you, forced you, pressured you to plead guilty to that offense?
No, nobody has, Your Honor.
Very good. All right, then the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the evidence?
No, sir.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
I don't think it's going to be a major issue because it's an order of deferred. But I see that the offense says assault of a peace officer, but the terms of the plea are obviously to an attempted assault. So should there ever be an issue in the future regarding any kind of revocation, I'm just kind of making a case note now that we need to pay attention to not the named offense, but what's in the plea agreement, because it's going to be to an attempted assault.
And yes, sir, I should have caught that. Normally there's a drop down on attempted on the offense line, but I didn't see that.
I think we've made a sufficient record of it here today, but Mr. Hartwell, just note your case. Ms. Burns, note your file that this is an attempted offense.
Yes, sir.
Yes,
All right, anything further from the state, Mr. Hartwell?
nothing further, Your Honor. Thank you.
And Mr. Hartwell, is the DA's office in compliance with victim notification? Is the police officer supportive of the plea?
We are, and the police officers are supportive, Your Honor.
All right, thank you. Mr. Schmidt, anything further?
No, sir.
All right, court will review the evidence.
My bill.
All right, the court has reviewed the evidence, finds enough evidence to convict Mr. Hogue of the offense. Court will follow the plea agreement today. The court places Mr. Hogue on deferred adjudication for a period of 3 years on the offense, the attempted assault of a peace officer, a third-degree felony. Court orders him to pay a $750 fine, $290 court cost, $520 in reimbursement fees. The court orders him to be placed on the mental health caseload, and the court dismisses the resisting arrest and criminal trespass that are unfiled from the DA's office. All right, Mr. Hogue, you're hereby remanded to the custody of the probation department. So in just a moment, you're going to step over to be fingerprinted with the officer, and after that, you're going to meet with the probation officers. And I want to make sure that you are very cooperative with your probation officers, and it's very important that you stay on your mental health medication so that we can get you through this process without you either, one, having to go to prison, or two, having to go back to Terrell State or some other state hospital. Okay, so it's very important that you
Yes, sir.
stay on top of your mental health meds. Okay, very, very important. You understand?
Yes, sir.
All right, step over there with the officer. He's going to fingerprint you, and then the probation officers will talk to you more. All right, is Miss Castillo in there, or are we
Here.
keeping them separate?
He's here.
She's here? Okay.
Gotcha.
For Castillo. And Mr. Schmidt, can you adjust that camera just a little bit so I can see Miss Castillo? She suffers from the same thing I do. It's called I don't know, verticalism or something. I'm not sure. Maybe horizontal.
I'm backing up.
No, you gotta hit that. You gotta hit the arrows. Just hit the arrows and it should go down.
So I'm doing.
It's coming.
It is.
See, I
If we still had such things as phone books, I would say get her a phone book, but there are no such
Take it
things.
off. Great.
There you go. Excellent. Good job, Sergeant Martinez.
You're stuck there.
Now I'm stuck holding it. Hold on.
That's fine. No, it's fine if you hold it. I got no problem with that.
Good.
It'll fall.
It'll fall.
Hold it.
And I'll hold it until she's here. Give me a piece of paper.
I'll just take my Dramamine here.
No, sorry. Good.
Patty knows how to work the arrows.
I think it's already down.
Yeah, it's all right. Yeah, all the way.
Who let Patty leave the room, first of all? Somebody's gonna get a demerit from that. All right, we'll talk fast. This is CR 24-256, State of Texas versus Jennifer Castillo. Ms. Castillo, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Your name is Jennifer Castillo, is that correct?
Yes.
And Ms. Castillo, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about any of the paperwork that you have read and signed today?
No, it's been explained to me, sir.
Mr. Schmidt, do you believe Ms. Castillo to be competent to enter into this agreement after you've advised her of her rights regarding your case?
Yes, sir.
And do you believe that she's entering into this intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Ms. Castillo, you were originally indicted with a third-degree felony offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. However, today I see that the agreement is for you to plead guilty to a lesser included offense of possession of a controlled substance in penalty group 1 less than 1 gram, that being a state jail felony. I see that the plea agreement further is upon you pleading guilty that your punishment would be assessed at 169 days confinement in the county jail with you receiving credit for time served. Also, you would be ordered to pay a $750 fine, $180 restitution, $290 in court costs, and $585 in reimbursement fees. Further, the state would be agreeing to dismiss and not prosecute you on a fraudulent use or possession of identifying information. Ms. Castillo, is that your understanding of the plea agreement?
Yes, sir.
Okay. Then I would ask you at this time, Ms. Castillo, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the evidence?
No, sir.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, Mr. Hartwell?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, court having reviewed the evidence, finds enough evidence to convict the defendant. The court will follow the plea agreement today. The court convicts Jennifer Castillo of the state jail felony offensive possession of a controlled substance in penalty group 1 less than 1 gram. The court will assess her sentence under section 1244A of the Texas Penal Code at 169 days confinement in the county jail. Court will give her credit for 169 days of time already served. The court assesses a $750 fine, $180 restitution. Further, the court orders her to pay reimbursement fees of $585, court costs of $290. All right, Ms. Castillo, once you are released from custody, you need to report to the Van Zandt County Courthouse during working hours between 8 and 5 and discuss with the district clerk's office about setting up a payment plan so you can discharge all of these fines and fees. The county will work with you as long as you're making a substantive effort to do so. Failure to make that effort or failure to report and pay will result in the court issuing a warrant for your arrest. Do you understand?
Yes, I have one question.
Good.
Wow. She wants to know how she gets back.
No, not just that. How am I gonna report it to them?
Give them a call. You probably won't get out of here before 5 p.m. So it'll be tomorrow. Give them a call and go up
Okay,
to the courthouse.
okay,
Yeah, and then you can make the decision.
okay.
Okay. Judge, I think that's all the pleas for today. We still have quite a few folks. I need a 10-minute recess. I've got to step over and grab my Ritz.
Yes, sir. Go ahead.
Thank you.
Wait, gosh. I don't have to.
Ms. Tabraham,
Yes, Your Honor.
do you have our KPS profile available?
I can go get it. Hang on just a second.
Okay. No rush.
Okay, Your Honor, this is Ms. Kaufman.
All right, good afternoon, Ms. Kaufman. We're having a hearing today on your capious profile. That's what you're currently in custody for. Ms. Tabram, is Ms. Kaufman being held on any other charges?
We go check.
Ms. Kaufman, are you aware? Are you being held on any other charges? I can't hear you.
No,
You're not? Is this the only charge? You weren't, when you were arrested, you weren't arrested for anything else? Intoxication, drugs, anything of that nature? Violence, nothing?
no,
Okay. All right, then I see that you have a capious profile, which means that's a warrant for financial obligations from a previous case, which was CR 12-246. And it says that you owe $1,148 from that case back in 2012. And you're aware of what case I'm talking about?
I think I took time on it. I did time on it, and it's gonna be a time served.
Okay, and when you did time, did you go to TDC or where'd you go?
Usually
TDC?
twice. I went to a rehab.
Yeah, give me just 1 second, looking at your case.
And Your Honor, she's here on a criminal mischief charge also.
Criminal mischief?
Yes.
Okay. And do you know what bill is set on that?
No, sir.
Using my name.
Let's see here. This is your judgment back from 2013. So it's for possession of controlled substance less than 1 gram. And looks like you were on probation and then you got revoked off probation.
Yeah,
And you received 4 months county jail time.
yeah,
And so whenever you went to county jail, this fine of $500, court costs of $418, restitution of $140, you were ordered to pay those things. And it appears that whenever you got out of county jail, and I don't see that you received any credit time, and the judge at that time did not give you credit for laying out your fines and court costs. So those are still things that you owe. Are you able to pay those things today?
no.
Okay.
Someone feels, no, I not.
Do you own any property or anything that you could sell to come up with that money?
No,
No? Were you working before you were placed in jail?
I'm hurt, on Social Security.
I'm sorry. And I'm sorry, I can't understand a word
I'm
you're saying.
disabled.
You're disabled, okay?
Yeah.
Were you receiving disability? And keep your hands out your mouth. That's one reason I can't hear you. Were you receiving disability?
Yeah, but somebody's doing it. It's hard to explain. I'm not getting it, someone else is.
Yeah, you don't get disability when you're in jail because you're in jail, but
Or doing it out of jail, I'm not getting it.
you're not getting when you're out of jail either. So,
I'm supposed to be getting it, but my boyfriend's getting it. I have a new boyfriend.
well, that doesn't make sense that your new boyfriend would be getting your disability.
I know, but he is.
Well, I don't know how you've managed that, but how much money does the government give you for disability?
$900
$900 a month?
something.
Do you have any other income? Do you make any other money? That's a no?
No, and I have heart problems and a monitoring device inside. I had a heart attack, so I paid for it. I've my last 3 days in charge and all kinds of stuff.
Okay. And do you know how much your bail is on your new charge, your criminal mischief?
It's 1,000, Your Honor.
It's 1,000? Okay. And how long has she been in custody?
3 days. You've been here 3 days?
Longer, but.
What's the first one? Christie. Oh, Christie.
Where was the criminal mischief at?
I don't know anything about the criminal mischief. That's a charge that I'm not dealing with today, and it might not be in my court. I'm just dealing with your old fines and court costs. Jail staff might be able to give you more information about your criminal mischief. But let me ask you this, do you support any children at home? Do you support anyone else other than yourself? No? Is that a no?
Take care of them, but, well, I
Is there,
mean,
is there anybody else that you are legally obligated to support at your home? Children, grandchildren, anyone in your legal custody? No? Is that a no? Is that a no? You gotta say yes or no. When you shake your head, I don't always know what you mean. No? And so you receive $960 a month. How much is your, I'm sorry, you receive 900 a month. How much is your rent? Do you have a rent?
I pay by the bill.
You pay what?
I have no bank rent. I don't pay rent. I have that.
So,
I don't pay rent. I live at my job. I had a job at one time paid me and they don't pay me no more and I live in an RV behind it.
okay, you live in an RV behind that, so you don't have rent. What about, so do you use your disability money for your, do you have utilities like electric and water?
He said he's thinking about charging me $200 a month.
Okay, they charge you 300 a month, and then you use the rest of your money for food and personal items. Is that correct?
Yes.
Yes,
Okay.
yes, sir. Yes, sir.
And you don't own any other property, right? You don't own vehicles or land or anything like that? No?
No.
Okay. All right, Ms. Tabraham, I've got an order that I will file with the clerk on costs, fees, and fines, and I'll just let her set it out.
She got here on August the 8th, so this is her 4th day.
She got here on August the 8th,
Yes, Your Honor.
been in custody 4 days. Okay. All right. So Miss Kaufman, when you get out of custody, I'm gonna give you credit on your court costs and things, so you won't have to pay them. So when you get out, it'll be resolved. This will be resolved. You'll still have your legal responsibility perhaps on your criminal mischief. So, well, we're not talking about that charge today. We're just talking about these old fines and fees that you never paid. Okay? Do you understand?
Yes, sir.
Okay. All right. Have a good day.
I never thought we got on.
Just a moment, Your Honor. Your Honor, we're ready.
All right, Mr. Schmidt, who do you have?
This is Samantha Maine.
This is cause number CR 25-155, State of Texas versus Samantha Laverne, Maine. And I believe that we're set on two things, arraignment and a possible writ.
Judge, we're gonna ask to abate the writ and proceed with arraignment at this point.
All right. Go ahead.
And Judge, her name is spelled correctly. We understand those charges. We'll waive formal reading of the arraignments and her pleas of not guilty on both charges and ask for a pretrial setting.
All right, this is also in cause number CR 25-169, the court finding that Ms. Maine has waived the formal requirements of arraignment in each case. The court enters her plea of not guilty into the record in each cause and will set each matter for pretrial hearing. Was there a requested date, Mr. Schmidt?
Just an early date next month, Judge, should be fine. I don't need a whole lot of time.
September 16th.
Yes, sir.
I could do 2 weeks from now, but that's probably too soon.
It is for a pretrial, Judge. I'm hoping that we'll be able to come to a resolution. If so, I'll ask Miss Patty to add her to one of those open dockets.
All right, and you said you wanted to abate your writ. Does that mean you want to leave it pending?
Yes, sir, if I could. And I'll notify Miss Tabraham in the next 48 hours or so whether we need to just non-suited and refile.
Okay,
Thank you.
you're welcome. Who's next?
This is Dustin Tinsley. I think we have an arraignment on him as well as the writ. Judge, same announcement. We're going to abate the writ, proceed with the arraignment.
All right, this is cause number CR 25-125, State versus Dustin Levi Tinsley, set for arraignment. Go ahead, Mr. Schmidt.
Judge, we understand the nature of the charges, name spelled correctly, wait formal reading, and her plea not guilty, ask for a pretrial.
All right, court enters Mr. Tinsley's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Do you want that early setting also, September 16th?
Yeah, with all of these custody individuals in custody, I'll go for the earlier setting.
All right, court sets Mr. Tinsley for September 16th and abates the writ WR 25-20.
And Mr. Shery.
Who is this?
This is Mr. Shirky, Mark, Adam.
All right, this is cause numbers CR 25-158 and 159, State versus Mark Adam Shirky, set for arraignment. Go ahead.
That's correct, Judge. At this point, we've gone over the indictments in both causes. His name is laid out correctly. He understands the nature of the charges. Waive reading, enter a plea of not guilty to both. In this particular case, Judge, I'm going to ask for a little bit of a later pretrial setting.
All right, court enters Mr. Shirky's plea of not guilty into the record in each cause, finding that he has waived the formal requirements of arraignment. And the court sets Mr. Shirky for pretrial hearing. Do you want September 30th or October 14th?
October 14th, please.
Court sets Mr. Shirky for pretrial October 14th in each cause.
That's amazing. Well,
Who is this, Mr. Schmidt?
this is Mason Hogue.
All right, this is cause numbers CR 24-233, 234, and FC 24-146. Show that we're set for docket call on all three. Go ahead.
That's correct, Judge. We've reached an agreement with the state. We'd ask to set Mr. Hogue for a plea.
You want to do it on the 26th, August 26th?
Yes, sir. That's fine.
All right, court sets Mr. Hogue to plea. Will that be a morning or that'd be or afternoon plea, I guess?
Afternoon, yes, sir.
All right, that will be set for August 26th at 1:30. Who's next?
Mr. Rigby. Yeah.
This is cause number CR 25-157, State of Texas versus Bobby Jean Rigby, set for arraignment. Go ahead.
Judge, we have received the indictment. He understands the charges and his name spelled correctly. We enter a plea of not guilty. Ask for a pretrial setting, and Judge, I'd ask for an early pretrial setting on Mr. Rigby.
All right, court enters Mr. Rigby's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Court sets Mr. Rigby then on September 16th for pretrial.
And Collier.
This is cause number CR 25-36, State versus Jimmy Dean Collier for docket call, final docket call. Go ahead, Mr.
If it's a final docket call, that's fine, Judge. I did meet with Mr. Hartwell. Mr. Hartwell intimated that they believe they had additional charges. I haven't had an opportunity to review the new allegations. Either way, as of right now, there's some things that I'm attempting to provide or will attempt to provide to Mr. Hartwell that perhaps may prevent the necessity for a trial. since this is a final docket call and this particular cause number, we'll announce ready for trial.
I'm looking at we've only had 4 settings. So I'm not sure why we would have gotten to final that quick.
I don't either, Judge.
Let's just reset it for another docket call. I may have written it on the wrong line, but this would only be his second docket call setting, I believe, if my docket's correct. So let's just set him for an additional docket call, and that'll give the state some opportunity to discuss with you if they have additional charges.
Yes, sir. Thank you. What was that date, sir?
Let's do September 3rd. You want to do September 30th or October 14th?
September 30th should be fine.
All right, court sets Mr. Collier then for docket call September 30th at 1:30.
He said for arraignment too, yes, sir. Yes. Yes. And a writ.
Also, we have an interpreter.
Have we had any before?
Yeah.
That for arraignment, but that, how many needed an interpreter? It's on my page 12. One of those new arraignments.
Yeah. So let's see.
That's me.
It is Martinez, Martin.
All right, this is cause number CR 25-166-167-168. State of Texas versus Orban Ariel Martinez Horazio. And we are set for arraignment.
That is correct, Judge. Unfortunately, I failed to mention, or we failed to communicate with the court that Mr. Martinez does not speak English and requires a Spanish interpreter. If the court would like to bring him back on Thursday, that's fine. We can do it then. I'll be here on Thursday. Or we can reset him for arraignment for a later day.
Thursday may be tough. I think we're pushing 80 on Thursday.
Yeah.
Let's just set him for the 26th. Because I'm not sure that Miss Tabraham can get a OCA interpreter by Thursday. So let's just set him for the 26th.
Yes, sir. August 26th, correct?
August 26th. All right, who's next?
This is Mark Thomas.
All right, this is cause number CR 25-17 -18 -123 -124, State versus Mark Aaron Thomas. I show that we're set for a docket call in all cases.
That's correct, Judge. I met with Mr. Hartwell last week. Unfortunately for Mr. Thomas and myself, we've had multiple communications about resolving his case. We have one idea of what that resolution was. Mr. Hartwell's notes don't reflect that. I know what I told Mr. Hartwell is that I was going to go through my papers and find documents that we had that would reflect what we thought we were agreeing to. I think that we still are going to resolve Mr. Thomas, but we've, for whatever reason, continued to find ourselves in a state of confusion. So I'm going to ask for an additional docket call, and me and Mr. Hartwell will work this out.
Anything, Mr. Hartwell?
Your Honor, I wouldn't be opposed to another docket call.
All right, court sets Mr. Thomas. Then is it fair to say we could do a final docket call
I
considering?
think it's probably necessary, Judge.
All right, court sets Mr. Thomas for final docket call. Do you want that September 16th or September 30th date?
September 16th will be fine.
All right, court sets Mr. Thomas for final docket call in all cases on September 16th.
Wow. Sort it out when we, sure. Yeah.
All right, who do we have next, Mr. Schmidt?
This is James Brown.
All right, this is cause number CR 21-321, State versus James Stevie Brown for pretrial. Also have the writ file. Go ahead.
That's correct, Judge. As far as pre-trial is concerned, we don't have any contested motions that need a hearing at this point. So we'd ask to set him up on a docket call.
All right, do you want September 16th or 30th?
30th would be good.
All right, court sets Mr. Brown then for docket call September 30th at 1:30. And do you want to go forward on your writ today?
Yes, sir.
All right, will you be calling your client to testify?
I will for the limited purposes of bond.
All right, Mr. Brown, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, the court finds that Mr. Brown is being called testimony for the limited purposes of the writ file seeking bail reduction. Go ahead, Mr. Schmidt.
Thank you, Judge. Mr. Brown, you're currently being held in Van Zandt County on a total of what appears to be $50,000 worth of bonds. Is that correct?
Yes, sir.
Now, you were taken into custody June 25th, 2025. Is that correct?
Yeah, yes, sir.
And so at this point in time, the state has indicted you on one of the two charges that you were arrested on, and that's that CR 21-321, correct?
Yes.
And you have an unindicted charge of theft of property, correct?
Yes, sir.
At this point, are you capable of posting $50,000 worth of bonds?
No, sir.
And do you have anybody at home who works who can come up with money to help you with bonds?
Yes,
And who is that?
my son,
And your son, what's his name?
Jake Stephen Brown, or Stephen Jacob Brown.
And I assume he's an adult.
Yes, sir. Yes, sir.
And so since you've been in custody, you've been unable to post that bond. Are you asking that the court consider granting you a reduction on those bonds so that you can be released pending the resolution of this case?
Yes, sir. Please.
Now, do you know of an amount of bond that you potentially could make if it were to be reduced?
I think if like 20,000, I guess I could, I'm probably more likely I could make it.
Okay, so are you asking the court to grant you a PR bond on the unindicted case and reduce the indicted case to $20,000?
Yes, sir.
And you think that potentially you could make that bond?
Yes, sir.
Now, if the court were to grant you a reduction as requested, would you have a place to live?
Yes, I got one.
And where is that located?
I'm 19. I've been there for 30 years.
What city is it in?
Canton, Texas.
So you're a Canton resident.
Yes, sir.
Do you have transportation and ability to get back to your court hearings?
Yes, sir.
And would you be able to get a job or work while this case was pending?
Yes, sir. I'm afraid about build houses.
Oh, so you're in construction?
Yeah, I got people out there waiting on me now.
Okay. At the end of the day, you understand that if you were to make bond, you'd be required to follow conditions of pretrial release.
Yes, sir.
And some of those would include reporting to the pretrial release officer every month. You understand that?
Yes, yes, sir.
You'd also have to pay a certain amount of fees towards lawyer fees and also supervision fees. You understand that?
Yes, sir.
Are you able to make those payments?
Sure will.
At this point in time, can you assure the court if you were to get the relief requested and you were able to bond out that you would make it to all your court dates until we get this matter resolved?
Yes, sir.
I'll pass the witness.
Jarwell, your witness.
Thank you, Your Honor. Mr. Brown, you were originally set for arraignment on November 30th of 2021. Is that correct?
Think so.
And you failed to appear that day, correct?
Yes. That's,
And then you were reset on March 9th of 2023 with a couple of settings in between, and you failed to appear on March 9th, 2023, correct?
yes, sir.
And you say you lived in Canton for 30 years. So if you've been here all this time, why are you missing court dates?
By that time, my mom died, but then my dad died about a few months after that. So I had a hard time through there.
And then moving on to your history, just for the limited purposes of this hearing, you have a couple of pen trips, right?
Excuse me.
You've been to the pen a couple of different times?
Just one time.
Just one time? One time, two different cases, maybe?
DWI.
And you also have some theft history?
Yeah, maybe.
And possession of controlled substance history?
When I was younger, yeah, 20.
No further questions, Your Honor.
Any redirect, Mr. Schmidt?
Yes, real briefly, Mr. Brown, this offense here, you just stated that you admitted to the prosecutor that during, I guess it was 2021, that you had failed to show up to court. Is that correct?
I guess it maybe it's been so long.
Okay, and at that time, you're not making excuses, but you have issues with traumatic event in your family?
Yes.
Did you have issues with transportation at the time?
Yeah, I mean, when my parents died, I didn't have the automobile at that time, but now I got an automobile, I got a couple of trucks.
So since that traumatic event, and you find yourself in a better position to take care of the business you're required to take care of, is that
Yes, sir.
correct?
Yes, sir.
All right, I'll pass the witness.
Mr. Hartwell, any follow-up?
No further, Your Honor. Thank you.
Any further witnesses or testimony, Mr. Schmidt?
No, sir.
All right. Any witnesses or evidence, Mr. Hartwell?
None from the state, Your Honor.
Mr. Schmidt, argument?
Judge, the only thing I would ask is that Mr. Brown is being held on 2 charges. Both, I presume, are based on my paperwork, dates of offense that are as far back as 2021. It may be that the statute of limitations on the theft of property may have run. I'd have to look, but either way, he's here and it's an unindicted case. On that case, Judge, we'd ask that he be granted a PR bond. And then I'm not sure. I think a $20,000 surety would be a reasonable bond for a criminal mischief offense, and it would assure that he make it to court as ordered.
All right. Mr. Hartwell, argument?
Your Honor, as far as unindicted case, state takes no position if statute of limitations very well may have run. On the indicted case, though, Your Honor, 2 FTAs already. Fool me once, shame on you. Fool me twice, shame on me. Really, I think another bond reduction is inviting Mr. Brown to not appear again.
Thank you, Mr. Hartwell. Any final word, Mr. Schmidt?
No, sir.
All right, and so my understanding is that Mr. Brown is indicted on the criminal mischief, which is currently set at 35,000, and there's an unindicted theft of property. What's the date of offense, the alleged date of offense on the theft of property?
It looks like it's going to be May 27th of 2021, Your Honor.
Okay. All right, court will take the evidence and arguments under advisement, and I'll issue a ruling at the conclusion of the docket.
Thank you, sir.
Sorry? Yeah, you're through, yeah. If you gotta give a reduction, he's gonna take under advisement and make a ruling at the end of the day. Okay, thank you, you got it. Exactly. All right, step back. The whole thing. Would say, okay. We'll come back.
I'll just make an announcement. On Mr. Atkins, Judge, we had a motion to reduce bail. We're gonna withdraw that motion. I believe that he's already set for the end of this month on the court's contested docket. So I don't believe we need a reset.
Is that Mr. Atkins?
That's correct.
All right, then, you said you want to withdraw it at this time?
Yes, sir.
All right, and you said he's already set.
He said on his motion to adjudicate. We just brought him in for this. I believe he is. I think he's on the contested docket.
You'll just write 9:30, just so I'll make sure I check.
If we want to go ahead and do a reset, we can, just to be sure. It don't matter to me. We've already got one filled out.
Just give me a second, I'll look. Yeah, he said on the motion to revoke August 28th at 1:30.
We're already. No, I'm just good. Stomach's in a turn. Looks froze. No, we're not. There's a size.
All right, who's next?
This is Casey Smith.
This is cause numbers CR 25-172 and 173. State versus Casey Patrick Smith for arraignment and for writ. Go ahead.
Judge, as far as the arraignment's concerned, we will waive reading on both causes, names correct, enter a plea of not guilty to both, and ask for a pretrial setting.
All right, the court finds Mr. Smith having waived the formal requirements of arraignment, enters his plea of not guilty into the record in each cause respectively. And the court will set Mr. Smith for pretrial hearing. What date do you prefer, Mr. Schmidt? 16th?
Yeah, September 16th, good.
16th? All right,
So-
court sets Mr. Smith September 16th at 1:30. You ready to go forward on the writ?
I think so. 1 second, please. So right there.
All right, Mr. Smith, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, thank you. You can lower your hand. Court notes that Mr. Smith is being called for the limited purposes of the writ requesting relief of bail. Go ahead.
That's correct, Judge. And when I filed the writ, none of Mr. Smith's offenses had been indicted. Obviously, we just arraigned him on 2, so there's subsequently have been indicted. But I'll proceed with my questioning as though he were unindicted, even though we all know that's not so.
Okay.
All right. Mr. Smith, you're currently in Van Zandt County's jail since April 25th, is that correct?
Yes, sir.
And you were just recently indicted on 2 of these offenses, and you're aware of that. We just did your ring. That's correct.
So
And you had been in here, was it close to 75 days prior to that indictment being returned?
when I got indicted,
Yeah.
how long it was when I got indicted.
Uh,
I got indicted on the 89th day. It should have been a day shy.
so they just got in under the 90 days. Okay. Now, at this point in time, your bonds are set in a cumulative amount, all total, set in total $27,500.
Yes, sir.
Now, that bond is relatively low considering the offenses, but have you had any opportunity to try and post that bond?
Sir, I've had opportunities, but as of recent, I couldn't get bond because Dad is the only one that was able to work. Mom just got a job, but it's at a Family Dollar, so, and Dad has a hard time paying all the bills.
You said you were talking about, when you say mom, Dad, you're talking about your parents.
Yes, sir, my parents, yes, sir.
How old are you, Mr. Smith?
I am 18 years old.
18 years old, okay. So if you were to get a bond reduction and you were able to get out, are you asking the judge for PR bonds, or are you telling the judge that you have the ability to come up with some amount of money to post surety bonds? Is the answer, I mean, it's either yes or no. You can come up with some amount of money?
Yes, sir.
And how much do you think that you could come up with
That's like for bond.
to pay a bondsman towards your bonds?
I really don't.
You don't know at this point?
I don't know. I don't know for sure.
Okay, but you don't have any assets of your own, is
No,
that
sir.
correct?
Yes, sir.
You don't have any money in the bank, you don't have any property that you own?
No, sir.
So any bonds that were posted, you'd have to rely on your parents.
Yes, sir.
And we're seeking a reduction, but you can't even really discuss that with your folks until you know what your bond's gonna be set at, correct?
Yes, sir.
But as of today, it's been unsuccessful trying to post a bond.
Yes, sir.
Now, where do you normally live, Mr. Smith?
As of right now, I'll probably go back with Mom because we were in Roy City, but Mom and Dad recently just split as of last year. So Dad went in Dallas, but I was with Dad in
Okay,
Dallas.
so when you talk about mom, what's mom's name?
Brandy Smith,
Brandy Smith, and she's your mother. Where is she currently?
Gilmer, Texas.
Okay, now if you went and lived with your mother, Miss Smith, in Gilmer, Texas, would you have the ability to get back and forth to court?
Yes, sir.
Because you know you have to be here, you already know the next day you have to be back.
Yes, sir.
Do you have your own transportation or are you
I do.
relying on your mother?
Relying on Mom.
Okay, are you going to try to get a job and work?
Yes, sir.
And you know that you'll have to pay pretrial fees when you get out.
Yes, sir. I do know that.
And so you'll be responsible for that, and because you're an adult now, your mother isn't responsible.
Exactly. Yes, sir.
Exactly, so you're gonna have to do that now. As far as, so you've got your living arrangements in Gilmer, your mother will have to give you transportation, and you understand you have to get back and forth to court.
Of course. Yes, sir.
All right, are you asking the judge to give you PR bonds on all of these cases? Or, and if not, then a reduction as low as possible?
Yes, sir.
I'll pass the witness.
Mr. Hartwell, any questions?
Your Honor, just very briefly, Mr. Smith, just as a matter of record, some things that the judge has to consider is criminal history. Now you're 18. So as an adult, have you had any criminal record as an adult?
Before that, no, sir. No, sir.
Nothing further, Your Honor.
Mr. Schmidt, any redirect?
No, sir, I'll pass. I'll rest.
All right, any evidence or witnesses, Mr. Hartwell?
None from the state, Your Honor.
All right, Mr. Schmidt, any argument?
Judge, I think under the circumstances, I would ask that the court grant Mr. Smith PR bonds, allow him to get out and try to get a job and start paying down some of the fees that he's going to owe. Allow him to meet with me out in public. I think that under the circumstances with no prior criminal history, there is relative youth. We'd ask for the court to grant him PR bonds in all cases, if not a reduction as low as the court is comfortable doing.
All right, Mr. Hartwell?
Your Honor, I think under the circumstances, obviously, Mr. Smith would be entitled to PR bonds or personal bonds in the two unindicted cases. in the two indicted cases, Your Honor, state would have no issue with reducing the bonds, maybe cutting them in half, but state would not be comfortable agreeing to personal bonds in those cases.
And which, so the two that were indicted were the evading arrest or detention of the vehicle and the unauthorized use of a motor vehicle?
Correct, Your Honor.
Okay. All right, anything else, Mr. Schmidt?
No, sir.
All right, court will take the evidence and arguments under advisement, issue a ruling at the conclusion of the docket.
Thank you, sir. So, we have a.
Is this Mr. Banda?
It is, sir.
All right, this is cause number CR 25-63, State of Texas versus Oscar Fabian Banda, set for docket call. Go ahead.
Judge, we'd asked to set Mr. Banda for a plea.
How soon would you like that, Mr. Schmidt?
No rush.
2 weeks?
Sure.
All right, court sets Mr. Banda then to play before the court August 26th at 1:30. Mr. Schmidt, did I overlook, do we have Mr. Holloway on our?
Yeah, we have read. You've been answering.
All right, this is cause number WR 25-17. This is a writ seeking a modification of bail, state of, or Gary Neal Holloway versus State of Texas. You want to call Mr. Holloway today?
Do, sir.
Mr. Holloway, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. Make sure you speak up loudly and clearly. Go ahead, Mr. Schmidt.
Mr. Holloway, you're currently in custody in Van Zandt County for a fail to comply with registering a misdemeanor assault. Is that correct? Yes, sir. Now, you when you look at the book in Van Zandt County Jail, it says that you were taken into custody May 15th, but that is incorrect, is it not? Yes, incorrect. You were arrested on May 1st, okay, in Hill County. So in Hill County, they executed a Van Zandt County warrant and took you into custody there, is that right? Yes, sir. And then you were actually transported over to Van Zandt County and booked in here on the 15th. Yes, sir. Were you arrested in Hill County, is that what you said? Yes, sir. Were you arrested on anything in Hill County? No. I didn't see any holds, so the only charges you have, wait for me to finish, because I'm long-winded. The only charges you have pending are the ones in Van Zandt County. Yes, sir. So as of today, you are still unindicted on all those cases, correct? As far as I know, you haven't been indicted on the fail to comply. Yes, sir. And no complainer information has been filed on the assault misdemeanor. Is that correct, sir? So you've been in custody over 90 days on both of these offenses without a charge being filed with the court. Now, your bonds are cumulatively set at $45,000. Are you able to make bond as set? And in addition to that, I think you've been having some significant health problems while in jail. Is that correct? Yes, sir. And what are those health problems? Bladder cancer and prostate cancer. So you're suffering from multiple cancers. I've been to the hospital 7 times since I've been here, and I'm due for surgery sometime this week. So you're due for surgery, and at this point in time, if you were out on bond, do you have access to health insurance? Yes, sir. So is that health insurance being used for the health treatment that you're getting while in custody? So the county is basically accruing a very large bill for indigent health on your behalf. Is that right? Yes, sir. So if you were actually released on PR bonds, you wouldn't accumulate all those charges, and ultimately you could attend to your health issues. Yes, sir. Okay. So at this point in time, you're still indicted, but in the event you become indicted, where would you reside if you bonded out? Canton. In Canton, Texas. And do you have the ability to get back and forth to court? Yes, sir. In the event that takes place? Yes, sir. And you'd be assigned conditions of pretrial release. Yes, sir. Which you'd have to comply with. You're aware of that? Yes, sir. All right. At this point in time, so you're asking the judge to grant you PR bonds in both cases? Yes, sir. Thank you. I'll pass it with us.
Good trouble.
Nothing from the state, Your Honor.
All right, so let me get my facts straight here. So Mr. Holloway has been incarcerated for over 90 days without an indictment in either cause.
Your Honor, I do see he was filed on in the misdemeanor. I don't know the date that it was filed, though, Your Honor. I do see a cause number for it, though.
All right, give me a moment. Let me look that up. All right, so the court finds that Mr. Holloway has been charged by complaint information with the offense of assault causes bodily injury that was filed with the court on June 24th, 2025. And so that would be 30 days after, if what Mr. Holloway says is true, that he was taken into custody on May 1st, and that would be 30 days after his arrest. Is that correct?
Correct, Your Honor. It'd be 54, 55 days.
All right, so he would have been entitled to a personal bond under 17-151 in that respect. Is it 30 days for a Class A?
I believe so. 30 days for a Class A.
15 for B.
15 for B. Okay. All right. Anything further from the defense, Mr. Schmidt?
No, sir.
Anything further, Mr. Hartwell?
No, Your Honor. Thank you.
All right, then the court finds that based on the evidence that the defendant is entitled to be released from custody, since there is no return of an indictment by the state prior to 90 days pursuant to Texas Code of Criminal Procedure, Article 17-151, the defendant then having a legal right to be released on a personal bond or on a surety or cash bond that the defendant can make. The court grants the writ. The court sets personal bonds for the assault, family violence in the amount of $10,000 personal bond and $25,000 personal bond on the failure to comply with sex offender duty to register. Board is signing the order on the writ of habeas corpus this day.
Thank you, sir.
Mr. Schmidt, does that resolve all of your cases today?
I believe it does, sir.
All right. Or let me have a look over the docket one more time. Ms. Tabram, are you aware of any other inmates that the court needs to hear?
And to my knowledge, Your Honor.
All right, that concluding the court's criminal docket, the court is adjourned for the day. Thank you for your work. And we'll see you all soon.
Thank you, Your Honor.
Thursday, soon.
Thank you, sir.
All right, you have a good
We'll see you in a few minutes.
Not if I get out of here quicker than you drive back.
Well, then you leave